Welcome back. In this video, we're going to explore copyright, copyleft, and fair use. Copyright is probably something you've all heard of. Copyleft is just the opposite. Rather than focusing on retention of all rights, the copyleft movement is focused on giving away rights. Fair use is an exception to copyright that is enshrined in the law. Before we get too deep into the weeds, let's define copyright. According to copyright.gov, copyright is a type of intellectual property that protects original works of authorship as soon as the author fixes the work in a tangible form of expression. The key words here are original works of authorship and fixed in a tangible form of expression. So the work must be original and it must be recorded in some way. Thoughts and ideas are not copyrightable, but once pen is put to paper, key to word processor, paintbrush to canvas, that thought or idea is fixed and therefore copyrightable. I know that earlier in this lesson I defined intellectual property as intangible. The thought, idea, or work of creativity is intangible, but the expression must be tangible or else anyone could claim copyright of anything and there would be no evidence of who actually owned what. I also want to define plagiarism, as copyright and plagiarism are often conflated. Per the University of Oxford, plagiarism is presenting someone else's work or ideas as your own, with or without their consent, by incorporating it into your work without full acknowledgement. Plagiarism is not necessarily a violation of copyright, it is a violation of academic integrity. You can violate copyright without plagiarizing. Imagine borrowing a figure from a commercial textbook and using it in a separate publication with an appropriate citation. That is not plagiarism, as you credited the original creator, but it may be a violation of copyright. Now, imagine you borrow an openly licensed image and fail to credit the original creator. If you don't know what open licensing is, we'll cover that a little later. For now, know that the licensing allows you to reuse the image without violating copyright. But because you failed to credit the original creator, this would be considered plagiarism. Not everything is copyrightable. Facts are not copyrightable. The tangible expression of facts can be. Let's say you write a poem about the position of planets. Planetary positions are facts and as such not within the purview of copyright, but your poem, that's a creative work. Ideas, by their nature, are also intangible and therefore not copyrightable. If you develop a novel conceptual idea of how to accomplish a task, you could describe it in words or drawing, which would be subject to copyright. That idea would then have a tangible form of expression, which would be subject to these laws. You might also file the idea as a utility patent for more full protection. Laws are also not subject to copyright protections. Similarly, most federal government publications are published to the public domain. Methods of operation are not copyrightable. They can be patented or subject to a trade secret protection, but not copyright. Copyrights also expire. Older works enter the public domain 70 years after the end of the original author's life. If a work is of unknown creative origins, that work is subject to copyright protection for 120 years. If a work is created for hire, it is subject to copyright for 95 years. If that seems long, it's because it is. Sonny Bono, under the lobbying pressure of the Walt Disney Corporation, introduced legislation in 1998, the Sonny Bono Copyright Term Extension Act, as Steamboat Willie was just about to enter the public domain. Copyright terms were extended to their current time frame, and then in January 2024, Steamboat Willie finally entered the public domain. So I can share this still or the entire video without running afoul of Disney's copyright. Finally, there is an additional complex exception to copyright: fair use. Fair use is a legal framework for reusing copyrighted content in certain use cases so as to not stifle innovation. Fair use is law, but it is a law with intentionally vague bounds. Fair use favors small portions of the original work, use in educational settings, non-commercial reuse, and parody amongst other criteria. It is not clear what constitutes fair use in the law, as the law is written in such a way that it is intended to be challenged in court by a copyright holder should they consider the use case unfair. Legal challenges pose a liability, so many publishers and some institutions prefer not to rely on fair use at all. Still, fair use is protected and enshrined in law. as an exception to copyright. One example of fair use would be the songs released by Weird Al. I believe he has gotten permission in all cases from the original creators, but his parodies of songs are protected even if he were not to have the artist's permission. Parody is so established as a protected use that it is highly unlikely, though I will say not impossible, that he would need to defend his use. Automatic copyright protections mean that there are a variety of statuses related to copyright. First, everything not under copyright protection is in the public domain. Frequently, this is related to time since creation. Less frequently, copyright holders choose to release things into the public domain voluntarily. The U.S. federal government releases most publications in the public domain, but this can be complicated by the fact that many government reports are prepared by private consultants. In such cases, the private consultants may retain copyright. Then, within copyright protected items, there are three primary, sometimes overlapping types of work. Commercial works are protected, and the owner is often a corporation. Commercial works are generally the most straightforward of all copyrighted works. Commercial entities want to protect their copyright and make the copyright known. Orphan works are things that are known or likely to have been made within the last 120 years, but the creator is unknown, or their next of kin are unknown, or they're unaware that they inherited a copyright. I suspect most things under copyright protection fall into this category. It is easier now than ever to create content, and copyright happens automatically, so much of this protected work is orphaned. Finally, there are free works. Open source software or open access publications are still subject to copyright until and unless the creator releases it into the public domain. Just because something is freely accessible or available on the internet does not mean that it is in the public domain. We'll get into some of the commonly used licenses that allow authors to retain rights while letting the public access their works. These different types of copyright statuses also may seem like they cannot coexist. So why then do I have them overlapping in the Venn diagram? Well, copyright is very complicated. For example, a couple years ago, I was assisting a graduate student with obtaining copyright permissions for their thesis. The student wanted to use a figure from a journal article published in the early 2000s. In the time since that article's publication, the journal had changed hands between a couple of large commercial publishers. I believe it was Elsevier and Taylor & Francis. And then it was purchased by the Japanese government, who released all back issues open access. So the title was freely available, but the copyright statement said that it belonged to the commercial publisher who owned the journal at the date of publication. Elsevier was contacted, Taylor & Francis was contacted, but neither publisher claimed to own the copyright, and each pointed the student who requested this permission toward the other publisher. This was a commercial open access, yet orphaned work, and it was probably the single most complicated copyright permission that I have encountered to date, but it serves to show that even modern commercial works can be orphaned. Open access publication is one example of free works. Open access builds on the ideals first deployed in open source software. Free and open access to information increases equitability and removes barriers to free flow of knowledge. Many governments, the United States included, mandate open access to all products of federally funded research. As far as open access publication is concerned, there are several pathways. Gold and green are the two most common options. Gold open access is a reversal of traditional publisher revenue streams. Under traditional publication, a publisher accepts a manuscript under the condition that they be transferred the copyright, then they publish it and charge libraries or individuals for access. Under Gold open access publication, the author pays a fee to the publisher and the article is made freely available immediately upon publication. These charges are referred to as article processing charges, or APCs, and are often written into grants if a publication is planned in advance of the grant application. Though access is free, the author retains copyright and generally uses a Creative Commons license. I'll cover these licenses on the next slide. Green open access is a compromise that many publishers have come to as a result of this mandated open access. Not everyone has funds to pay article processing charges, but publishers still need material to publish. Green open access allows compliance with these mandates, but it comes with some caveats. Green open access is a form of self-archiving. The author uploads a copy of their manuscript to a repository or archive. Publishers typically require a preprint version to be uploaded, so none of the editing and formatting that the publisher has done are shared openly. The publisher will also generally require the paper to be embargoed to public access for a period of time so that the published version is exclusive to the publisher initially. In this example, shared on the slide, Taylor and Francis allows library journals to avoid embargoes, but all other journals are embargoed. Additionally, with Green Open Access, the publisher generally owns and retains the copyright and will likely require you share a statement to that effect with the openly shared version. Creative Commons licenses are also often referred to as copyleft. Creative Commons is a nonprofit organization who seeks to allow copyright holders to retain certain rights while freely releasing their works and making it clear what use cases are permissible. If a content producer wants to release their materials to the public domain, they may do so with a CC0 license. These are somewhat infrequently used, but are appropriate for people who don't want to conditionally release their works. While still retaining some rights, the least restrictive Creative Commons license is CC BY, or an attribution license. This requires anyone using the work credit the original creator. Basically, it stipulates that everything outside of plagiarism is allowable. There are 3 additional conditions that are allowable within the Creative Commons schema, and they can be combined. These conditions are no derivative works. I generally advise against using no derivative licenses in academic works. Scholarship relies on derivations, and copyright lasts so long that it's likely a license like this will result in an orphaned work and hinder use. That said, it might be useful for creative works like music or visual arts where you don't want your work to be altered. Share alike ensures any derivative work is licensed like your work. This is a way of ensuring derivations do not change the licensing terms. Share alike and no derivatives licenses are mutually exclusive. If derivatives are not permissible, you cannot share a derivative. Finally, there is a limitation to non-commercial. This prevents someone from taking your work, publishing it for profit. You may decide after publication to change a license, but this can only move towards less restrictive, not more restrictive. Obtaining permissions is common in theses and other publications where you may need to use substantial portions of pre-existing works. You may also find yourself in a situation where a work such as your thesis contains materials you intend to later publish with commercial entities. Depending on your discipline and where you intend to submit, this can be considered previously published and rejected outright. Often you are permitted by your graduate school to embargo your thesis for a period of time. And what that does is it prevents the public from accessing your work while fulfilling your graduation requirements. You hold the copyright until it is transferred, so generally this is considered acceptable by most publishers. If you use copyrighted works where you don't own the rights, you will likely need to obtain permissions. Fair use allows reuse under certain conditions, but as I mentioned before, it poses a liability as it can be challenged in court. For this reason, especially in commercial publications, if you reuse any substantial portion of a work, including extended quotes, figures, tables, and graphs, you will likely need to obtain permission for reuse. Notably, you may be able to recreate a table or graph. Data is generally considered fact, and as such is not subject to copyright. Only the tangible form of expression is. So if you are given the data and plot a graph yourself, you can do so without permission. Just be sure to credit the original creator to avoid plagiarism. It is also possible that you want to reuse copyrighted materials you created, but have since transferred the rights away to a publisher. You would require permission in this case as well, unless your use case is specifically permitted under the terms of the copyright transfer agreement. Obtaining permissions may sound like a tall order, but it is generally pretty painless, and in the case of theses, also typically free. In most cases, the process has been largely automated by the Copyright Clearance Center. The Copyright Clearance Center is a commercial entity that acts as an intermediary between publishers and those who want to reuse their copyrighted content. You can visit their site directly and search for a particular book or article, or you can look for the rights link present on most journal web pages. It typically says something like get rights and content, or as is the case in the example that I have on this slide, reuse and permissions. This auto-populates a form with the Copyright Clearance Center, and then you just select how you intend to use it, including the portion, the title of your publication, and whether you intend to translate, as well as the appropriate number of copies you expect will circulate. In the case that permission cannot be obtained through Copyright Clearance Center, you need to obtain the copyright holder's permission directly. In the case of commercial entities, there's often a Contact Us page on their site where you can reach out. In the case where individuals hold the copyright, Creative Commons no derivative license is used, for example, or you intend to share the copyright with co-authors, you will need to reach out to all copyright holders and seek permission. As with the rights link form, include as much information as you can. Definitely include the portion of their work that you're intending to use and the title of your work. Depending on where you intend to publish, this generally does not require a great deal of formality and does not need to follow any particular language. I hope you found this information valuable. Copyright can be a bit of a challenge, but I hope that learning a little bit more about it helps demystify some of the important concepts related to this type of intellectual property. Up next, I have put together an activity where you search for permissions and look at journal policies in your discipline. After that, I have a short concluding video.